A judge in America has ruled that the National Security Agency may have violated the Constitution by collecting telephone data. The decision follows a lawsuit over violations of privacy, and it's the first time such a judgment has been made in open court. The judge ordered to stop collecting the plaintiff's data and for information already gathered to be destroyed. However, the decision can't come into force because the government has at least 6 months to appeal. Chris Kitts, the owner of a secure online messaging service who moved his company to avoid U.S. intelligence control, says everyone would comply with legal searches, but not mass secret surveillance.
It's not a strong argument compared to the right of people to have privacy in their papers from unwarranted searches. So what's basically happening, the argument the government's making is that the metadata that they're collecting, which is all the information about the phone calls, who called who, at what time, how long the call was, all that information, they think that's fair game, that they should be able to grab as much of that as possible. Most people who look at this, from a situation like a normal person would say it's just like wiretapping. The reality is this: they don't need to do a dragnet on everybody. If they really care about terrorists, I mean, most people would say, yeah, if there's a suspicion or a reason for people to be surveilled like this, go to a judge, get a warrant. We'll cooperate. Everybody I know in this business would cooperate with a legal, warranted search. But when you go on a fishing expedition to catch every fish in the ocean and then throw 99.999% of them back in the water, that's not good.
And the American public deserves a chance to see how the Secret Services get permission to monitor data. That's how Edward Snowden, who opened the world's eyes to the NSA's massive spying operation, commented on the judge's decision. He says it was the main reason behind his actions. Josh Kirstein, a senior White House reporter, considers that Snowden's revelations made the courts take the side of the victims of surveillance.
In the past, these kinds of lawsuits have failed because the courts and ultimately the Supreme Court concluded that it was too speculative, that the individuals who were suing couldn't really show that there was a high likelihood that their communications had been tracked or intercepted. That's why the Supreme Court threw out a case like this a couple of years ago. But in the wake of the Snowden disclosures, there are now documents, public records, and declassified information about how this program works that indicate that virtually every American is affected by it, in that if they use a telephone at any point to receive a call or make a call, it's very likely some information about that call is being retained by the government for 5 years. So the judge essentially found that the scene here, the background has basically changed, and that individuals who sue over this now do have standing to pursue their suits.
So while the NSA's appetite for personal data seems far from being satisfied, some groups have found quite an unusual way to stand out for digital privacy.
You better watch out, you better not Skype, you better log out, yeah, you better not type. The NSA is coming to town.